This is the Con Law February 2015 bar examinations, and we are just going to walk you through what we've done. We've already highlighted to make it shorter. First thing you want to do is you want to go to that one line at the end, the call of the question. The firefighter is considering challenging the act on the basis that it violates his right under the 14th Amendment Equal Protection Clause and lobbying for the enactment of a federal statute barring states from setting mandatory limitations for firefighters. So at this point, you already know that you have to discuss the 14th Amendment Equal Protection Clause. At this point, you already also know that you're also going to talk about the different levels of scrutiny, you understand. And then when you get here, lobbying for the enactment of a federal statute barring states from setting mandatory age limitation for firefighters. Then you get to question 2. It says, would Congress have authority under Section 5 of the 14th Amendment to enact a statute barring states from establishing a maximum age for firefighters? Now, by the time you look at this, you know that we're talking about what? Commerce Clause, the powers of the Congress, and all of that. So you can now start analyzing as you're going in your mind. Now, State A, suffering from declining tax revenues, sought ways to save money by reducing expenses and performing services more efficiently. Accordingly, various legislative committees undertook examination of the services performed by the state. So now we know that the state is having a problem with what? With expenses. So it wants to reduce its expenses and perform services more efficiently, right? So, and then one service provided by state A is firefighting. So the Legislative Committee with jurisdiction over firefighting held extensive hearing and determined that older firefighters, by the time you get here to older firefighters, you're beginning to understand that we're talking about age somehow. Determined that older firefighters, because of seniority, earn substantially more than younger firefighters. So why do older firefighters earn more? Just because of seniority, but are unlikely to perform as well as their younger colleagues. So in particular, exercise psychologists testify. So now we have evidence of committee hearing, right? That in general, a person's physical condition and ability to work safely and efficiently as a firefighter decline with age, right? So the older ones do not perform better than the younger ones, but they earn more. So that is a problem, right? With the most rapid declines occurring after age 50. So once a person has gotten to age 50, the person's performance start declining. And that as a result, firefighting would be safer and more efficient if the age of workforce was lowered. So now they want to lower the age of workforce. So you can see what we wrote on paragraph 1. We just summarized what we have here. The older firefighters earn more, but they are unlikely to perform. Physical condition declines with age. 50 years is the age limit. And safe firefighting will be attained if lowered workforce age. Now, for this paragraph 1, we want to look at the rules that associate with it, right? Non-suspects, the scrutiny level, we know its rational basis. There must be a legitimate reason. Our legitimate reason here, we know. So, you always have to analyze every rule according to the facts. We have safety plus efficiency plus cost saving. Okay, that's their legitimate reason, right? So we have safety, efficiency, they're not working as efficient as the younger ones, and cost saving, they're trying to save costs, they're trying to save expenses for the state, right? So evidence presented, right? Evidence presented. Now we're trying to bring out our rules and analyze. So the paragraph builds a justification that the state will use to survive the rational basis scrutiny. Okay, so that's the essence of paragraph 1. That's justification, the evidence of the committee and all. So let's go down to paragraph 2. State A subsequently enacted the Fire Safety in Employment Act. So now they've now taken action, they've now enacted an act. And the act provides that no one may be employed by the state as a firefighter after reaching the age of 50. Okay. So, we're teaching about how you should outline your work. So after reaching the age of 50. So we're going to go down Yeah, paragraph 2, we know that whenever we see an act, we are looking at the classifications. We are looking at whether or not that law is discriminatory on its face. Is it discriminatory on its face? Does it discriminate against a particular group, either on its face or how it's applied? We have a facial classification. We have a clear discrimination based on age. The age is there, 50 years. Once you're 50 years, you cannot be hired because of the safety and efficiency and cost saving and all the legitimate reason the state gave. So this triggers the rational basis scrutiny. The government must show that the law is rationally related to a legitimate state interest. And let us always remember that when it comes to those rational basis tests, the court will always support the state most of the time, because the rational basis test is like the least. The state would always have a good reason. Okay, so there is legitimate interest. Yeah, we know. So the state wins. Okay, so let's go to paragraph 3. A firefighter age 49, so this is a plaintiff now, is employed by state A. He is in excellent physical condition. So they are now trying to see if they can make you bring in emotions. So we need to asterisk that very well. And wants to remain a firefighter. His work history has been exemplary. Sometimes when you do some counter arguments during the exams, it can also help boost your score. We'll see how this is going to help us. The last 2 tickets. That as a result of the act, his employment as a firefighter will be terminated when he turns 50 next month. Oh my God. Just 1 month. This bar examiners, they know how to make somebody think. Okay. So let's look at paragraph 3. Hardship of plaintiff, but does not matter and cannot change scrutiny. So as you're going, you're putting down your thoughts on the side. The court differ heavily to legislation. Counter argument. The plaintiff can argue that the law is over-inclusive and under-inclusive, but this doesn't kill rational basis test. If you can state this during the bar exams, that's going to be very good. It's going to boost your point, okay? This is an insight for your exam. This paragraph is giving you counter argument. Plaintiff says age 50 cutoff is arbitrary, but under rational basis test, perfect fit is not required, okay? Doesn't matter what you think, doesn't matter if you feel it's arbitrary. As long as the state has a legitimate interest, they can cut off the age. So they don't look at your emotions to determine what to do. So let's go down to the firefighter is considering A, challenging the act on the basis that it violates the rights under the 14th Amendment Equal Protection Clause, and B, lobbying for the enactment of a federal statute barring states from setting mandatory age limitation for firefighters. So he wants to lobby. Okay. Does the act violate the Equal Protection Clause of 14th Amendment? Explain. So if you are my mentee, if I'm taking you, you get a PDF of this, just the way it is. It helps you to just review through the rules quickly and understand the question better. I do a lot of these for my mentees, and you also get the video walkthrough. So let's go down. Will the Congress have authority under Section 5 of the 14th Amendment to enact a statute barring the states from establishing a maximum age for firefighters? Explain. So we know that question number 2 is talking about whether or not the Congress can actually bar the states from establishing a maximum age. Is it within the powers of the Congress and court? Yeah, under Section 5. We need to also know what Section 5 talks about and whether or not Section 5 also includes a power to prevent the states from establishing a maximum age for firefighters. Let's quickly go down to side notes. For question 1, on the side during your bar exams, you want to put EP analysis, because it's very important you read through the 2, because sometimes you might be answering question 2 under question 1 and you will not know. So question 2 talks about Congress Section 5 powers. So for issue 1, I want to show you how you should draft your issue. When you're drafting your issues in the bar exam, please do not draft your issues exactly how the question is said. You want to draft it in accordance with the facts of the case, okay, most of the time. So if you go down here, it says, let me show you how I drafted my issue. Whether state A's Fire Safety in Employment Act, which prohibits individuals over 50 from serving as firefighters, violates the Equal Protection Clause of the 14th Amendment. That's it. So we have brought in the statute we're trying to look at. We've brought in what the statute is trying to do. And we have brought in what particular part of the Constitution we're trying to see if it violates. You understand? And that's it for Equal Protection Clause of 14th Amendment. So this is how your issue statement should be. This is how your issue statement should be for issue 1. Then let's look at our issue statement for issue 2. We already know what the answer is. If you are in the exam hall, you want to quickly start writing out your issue or typing out your issue. You don't need to write it out here. You understand? For your conclusion, you can say, no, the law does not violate equal protection. State wins under the rational basis test. Okay, that is at the side. And then if you're outlining alone, maybe you're at home and you just want to outline as many past questions as possible, this is how you should be outlining. So you can be training yourself on how to draft a good issue, how to draft a good conclusion, and all of those, and then how to analyze. You know, you're analyzing from the top and you're going through it in your mind, how it should be. A rational basis test, all other classification, including age. I put it here on the side for you to help you try to remember. We can say age is not a suspect class or quasi-suspect classification. Therefore, the statute is evaluated under the rational basis test, which asks, does the state have a legitimate government interest? Is the age classification rationally related to the interest? Okay, so under the rational basis test review, the state receives broad deference and the law will be upheld if any conceivable legitimate purpose actually exists. Okay, so the conclusion, we all know. So when we go to, so that's the rule, right? So that's the rule. When we go to the analysis, we look at the statute, the Fire Safety in Employment Act. We can now determine that it has a facially based distinction by mandating retirement at age 50. So you have to pick that out first, right? So since age is not a protected class, the rational basis test applies. Then we now go down to legitimate interest. So now you start picking it out. You pick out the rule and then you try to connect it with the facts. It says state A identifies several interests: promoting public safety, improving the physical fitness of its firefighter force, enhancing efficiency, reducing personnel costs tied to seniority-based pay. All of these interests are legitimate state purposes. Okay, so as many as you can bring out to show legitimate interest. And then you now go down to rational relationship. You go down to the fact that the legislature relied on a testimony. So even if the individual firefighter at issue is in excellent condition, that's where your counter argument comes in. The Equal Protection Clause does not require individualized assessment on a rational basis test. The legislators may draw generalized lines so long as they are not arbitrary. So existing Supreme Court decisions have upheld similar mandatory retirement ages for physically demanding public safety roles. And this supports the finding that the statute is rational, even if it's over-inclusive. Can you see how your argument should go? Let's go down to the conclusion. As a conclusion, the Act does not violate the Equal Protection Clause. Age-based classification receives rational basis review, and the statute is rationally related to legitimate interest in safety, effectiveness, and fiscal management. State A is likely to prevail. Okay, so that is for that. Now, let's go down to the issue 2. See how I crafted out my issue. Whether government may use Section 5 enforcement power under the 14th Amendment to prohibit the states from imposing mandatory or age limits on firefighting. Let's remember the congruent and proportionality rule here. So the rule we know under Section 5 authorizes Congress to enforce 14th Amendment, create remedial legislation that prevents or addresses constitutional violation. But the Congress may not define or expand constitutional rights. They cannot elevate or They cannot elevate non-suspect classification like age into protected classes. They cannot prohibit conduct by the state that is not unconstitutional. The Congress enactments must be congruent and proportional to actual constitutional violation by the state. Okay, we understand this, right? Even if the Congress is authorized to enforce 14th Amendment, they can create remedial legislation that prevents and addresses constitutional violations, but they cannot define or expand constitutional rights. They cannot elevate one suspect classification like age into a protected class. They cannot prohibit conduct by state that is not unconstitutional. Okay. So as long as the state is not doing anything that's unconstitutional, they may not prevent the state from enacting. So the Congress enactments barring states must be congruent and proportional to actual constitutional violation by states. So you cannot single out state A and bar state A. Our analysis is age discrimination unconstitutional. Is age discrimination unconstitutional? Under the Equal Protection Doctrine, age discrimination is reviewed on a rational basis and is usually upheld. Thus, age-based classifications generally do not constitute constitutional violation. So, would a federal ban remedy any constitutional injury? So that's the way you look at it, right? The answer is no. Since mandatory retirement ages for firefighters are constitutional, there's no constitutional injury for Congress to prevent or correct. So 3 is, would Congress be redefining equal protection? Yes. A federal law prohibiting mandatory retirement age would effectively expand equal protection protections and will convert age into a protected class, will prohibit behavior that the Constitution allows. And so this exceeds the Congress remedial authority. Then congruent and proportionality. There is no pattern of constitutional state age discrimination. A federal ban will be disproportionate to any constitutional harm, right? So that's how your analysis should go in this second part. For your conclusion, the Congress does not have the authority under Section 5 to enact a statute barring states from imposing age limits for firefighters. Such a law would expand constitutional protection beyond existing equal protection doctrine and would not be a congruent or proportional response to constitutional violations. Okay, so that is it. This is a clear, already stated principle and everything for you. So if you are my mentee, you get this. So I wish you all the best.